Really, what we ended up finding is not that criminologists are more criminal than anybody, but they are pretty much on par with the average Joe.
Were the pictures. And there are pictures of at least one of the victims in his photo roll.
On his phone, according to People magazine and News Nation's reporting as well, on Bryan Kohberger's phone, numerous pictures of one of the victims.
Says that after they arrested Bryan Kohberger, they took his phone.
This is Reporter Room with Jessica Della Davies.
Welcome, Reporter Room investigators. Today we're going to be talking about Bryan Kohberger. Will he be convicted in the October trial, or will he walk free? Today we're going to be talking about Brent Kopacka, DNA, the planting of evidence, and Bryan Kohberger. Bryan's defense team has done a wonderful job of speaking to us through their motions. I think Ann Taylor is extremely smart. So Bryan's defense team has a couple of different options to defend him, and this includes pleading insanity, pleading diminished capacity, duress, or denial of a speedy trial. And I believe the prosecution is concerned about the speedy trial, and this is why they're asking Judge John Judge to reconsider that 37-day extension while still giving Bryan a speedy trial. The prosecution is asking for Bryan to waive his right to a speedy trial if he wishes to have an extension. Now, I'm going to discuss Brent Kopacka and the planting of DNA evidence in just a moment, so please stay with me. As always, Bryan is innocent until proven guilty, but because he is the only one who has been indicted, arrested, and is sitting in jail, I am going to be talking about this crime in terms of Bryan Kohberger. Let's go through the various defense options that Ann Taylor has available to her. If a defendant is legally insane at the time he commits the crime, he can be found not guilty by reason of insanity. But the defense cannot claim insanity because Bryan was sane and even working as a teaching assistant at the Washington State University. They could also try pleading diminished capacity. But again, Bryan was smart. Maybe not genius smart, but smart enough to get his master's degree in criminology. The defense can't plead duress because these four students were at home enjoying their evening. They weren't bothering Bryan in any way. So I believe the defense was trying to get a speedy trial appeal ready by requesting this 37-day extension while maintaining Bryan's right to a speedy trial. As I just shared, we saw this in the Lori Vallow Daybell case, and she definitely used it to appeal. So this is why the prosecution has put forward a motion not to grant this 37-day extension unless Bryan waives his right to a speedy trial. So let's talk about planted evidence and Brent Kopacka. The defense is going to claim that Bryan's DNA was planted by law enforcement. To do this, they're going to have to impugn three different arms of law enforcement: the Moscow Police Department, the Idaho State Police, and the FBI. The jury is going to have to believe that all three agencies conspired to frame Bryan Kohberger. And as I've shared with you in prior videos, if law enforcement simply wanted to frame someone, there would have been much easier people to frame. I mean, let's face it, no one had even heard of Bryan Kohberger prior to his arrest. So the easiest people to frame would have been one of the two surviving roommates, Kaylee's ex-boyfriend, Jack D., or even Brent Kopacka. So why would they pick some unknown guy like Bryan Kohberger that was a teaching assistant and lived 15 minutes away from the victims to frame? Nobody ever heard of this guy. And for everyone who's talking about Brent Kopacka, I looked into Brent Kopacka. I have been on this case since the beginning. I looked into Brent Kopacka months and months ago. Go through my video playlist and look at it. I looked into the connections. I couldn't find any connections between Bryan or Brent other than the fact that they both lived near each other. There's no known connections that the two even knew each other. Zero. Nada. Zilch. None. So I think if law enforcement wanted an easy patsy, Brent would have been an easy one to pin it on because Brent is not here to even defend himself. It also would have been easy for law enforcement to go in, get Brent's DNA because he did away with himself, and plant it. Because again, Brent isn't even here to defend himself. However, I do believe that law enforcement was actually trying to get the real person who actually did this off the streets to protect other young people. We have so much stuff to get into. Welcome to all of our new subscribers. We have hundreds of people who are newly subscribed to Reporter Room. Welcome. Thank you so much for helping us get to 30,000 subscribers. If you haven't subscribed, please do like, share, leave a comment, and consider hitting the thanks button if you are finding this information, this researched information, to be helpful. Let's talk about that 8-hour time gap. It is a legitimate concern, but both roommates, Bethany and Dylan, are stuck under a court-imposed gag order. So before we ruin the lives of two young women who so far's only crime that we know about has been to survive a brutal attack on their roommates, why don't we wait for the trial and actually hear what they have to testify to? Let's hear what they have to say. They were both thoroughly investigated by law enforcement and they were cleared. So I think it's important to remember that Bryan was not known to anyone, including law enforcement. This wasn't the OJ case where he was a famous football player who had had the police called on him prior by his wife, which is what happened in the OJ case. So law enforcement actually knew who OJ Simpson was. So do I think OJ did it? I do, in my opinion. So nobody knew anything about Bryan, including law enforcement. And I think it's important to remember this because in order for evidence to actually be planted, there would have to be a plan, a conspiracy by 3 different law enforcement divisions. So to believe that this DNA evidence was planted, we're expected to believe that the Moscow PD, the Idaho State Police, and the FBI, all of these people went along with this plan to frame some unknown guy. And if law enforcement was going to frame this unknown guy, then they would have to get his DNA. The DNA of a guy who supposedly wears rubber gloves when handling his garbage. And law enforcement would have to believe that this would be the only DNA that you could find on that knife sheath. And they would have had to have planted it. No. So Bryan's lawyers and Taylor also hinted at the latest hearing that they're going to impugn the qualifications of some of the law enforcement investigating this case. I don't think the DNA was planted. The defense is not trying to discredit the direct DNA testing sample that was the cheek swab obtained directly from Bryan from a court order. It was legally obtained, and this DNA sample showed there was a 1.37 octillion, not million, not billion, oct is 8, octillion chance of Bryan's DNA on the snap of the knife sheath found partially under and to the side of Maddie Mogen. In short, the DNA was a match to Bryan and only Bryan. Defense cannot use any of the normal excuses like insanity because there is no evidence that Bryan was insane. They can't argue diminished capacity because he had a master's degree in criminology and was working on his PhD. They could argue duress, but I don't think the jury's going to have a lot of sympathy for Bryan. If he was stressed out, and he probably was, but to go out and do away with 4 innocent young people because you're stressed out, 4 innocent people who were minding their own business inside their own home. So the defense is pretty much stuck with arguing that it was a setup. We have evidence that Bryan was under duress. Bryan was known to have anger issues. He had 2 altercations with his male professor, so I believe he was under duress. However, no one is going to feel sorry for this guy. There's no excuse to go, I'm upset, I got let go of my teaching assistant job, so I'm going to go do away with 4 innocent young people. No, that is not going to fly with the jury. So the defense is using the classic constitutional violation strategy to defend him. It's their only option. Please let me know what you think in the comment section below. Because this DNA ended up to be 1 in an octillion, not billion, not million, octillion chance, it's going to be very hard for him to overcome this DNA evidence, in my opinion. All opinions are welcome. You don't have to agree with me. All I ask is that you leave your opinion respectfully. Subscribe.